Which box? This one or this one? That one, okay. Calling Ronald David Valadares Castillo. Interpreter. This is Judge Allen. Can the interpreter hear me?
Good morning, Your Honor. This is Alan Figueroa, Assistant Vice President Interpreter. Yes, I can hear you.
All right, good morning, Mr. Interpreter. This is Mr. Ronald David Valladares Castillo, case number 2021 MM 475AA. Mr. Castillo, can you hear the interpreter? I'll take that as a yes.
Sí, la escucho.
The defendant can hear me, Your Honor.
All right, thank you, Mr. Interpreter. Mr. Castillo, you're charged with battery domestic violence. The court does find there's probable cause. The court will at this time order a bond of $500. No witnesses, a bond of $500. Order no contact with the victim. Order that you possess no firearms or weapons as a condition of your bond. The public defender is appointed to represent you in this case, sir. Who gets? I'm sorry. Is this a battery also? You know what the charge is? Is it a battery? Yes. As to the case that you're currently on bond, the court's going to revoke that bond, sir. Now, do you want to get these after I'm done with them? Thank you.
Disculpe. Una pregunta.
No, I signed them all at one time, which is better.
I'm sorry, can I ask a question?
Like, really quick, like, so I don't have to fall behind. Next case, Patrick Donald.
Okay.
And Mr. Interpreter, thank you. My understanding is we have no more interpreter cases, so you can disconnect. Mr. Donald, sir, you're charged with battery domestic violence. I do find probable cause for that charge. The court will set a bond in your case at $500. Order that you have no contact with the victim in this case. Order that you not return to the location where this incident occurred. Order that you possess no firearms or weapons as a condition of your bond. Thank you, sir. Crystal Nicole Johnson. Ms. Johnson, ma'am, you were picked up on an outer county for violation of your probation. The county is Seminole County. Bond will stay set at no bond. Thank you, ma'am. Did I forget one? Gage Ange Keaton.
Yes.
Mr. Ange Keaton, the court does find probable cause for the charge of aggravated battery with a weapon, domestic violence, and bond is set in that case at $1,000. The court finds probable cause for false imprisonment. Bond is set at $3,000. The court further orders that you have no contact whatsoever with the victim, that you not return to the location where this incident occurred. However, the court will allow you one opportunity to return or retrieve personal belongings in the presence of law enforcement. And the court is ordering that you not possess any weapons or firearms as a condition of your bond. Thank you, sir, and I am appointing the public defender. All right, Ms. Kateria Inya Bernard Villegas. The court finds probable cause for the charge of child abuse. Bond is set at $1,000. The court finds probable cause for the charge of battery. Bond is set at $500. The court orders no contact with the victims, no return to the location where this incident occurred. The court is also ordering that you possess no firearms or weapons as a condition of bond. and ordering that you be allowed one visit to retrieve personal belongings in the presence of law enforcement, public defenders appointed. Thank you, ma'am. 500. Let me look at that again. Oh, here it is. Oh, yes, 1,000 on count one, 500 on count two. Stephen Glass, Mr. Glass, the court, yes.
What?
Who usually announces case numbers? The clerk doesn't do that?
What now?
Well, what about this thing?
There was a victim?
He doesn't want to speak.
I don't know. I'm trying to figure it out.
Yeah, I mean, where's the scan barcode at?
Yes or no?
For every case? But that's the same for every case? But if I do the case number, it's different. So which do they prefer? Yeah, I'm not gonna do the scanning. But I'll do the, yeah, yeah. That's just another move. It's easier for me to just to talk more than to.
It was another
Yeah,
one.
I guess that'll be easier for the court reporter too. All right, Mr. Glass, case number 2021 CF 13277AO. The court finds probable cause for false imprisonment and bond is set at $3,000. The court finds probable cause for battery, domestic violence, bond is set at $500. The court finds probable cause for possession of a firearm by a convicted felon. Bond is set at $4,000. The court is ordering that you possess no firearms or weapons as a condition of bond, that you have no contact with the victims whatsoever, that you not return to the location where this incident occurred. You will be allowed one opportunity to return in the presence of law enforcement to retain personal belongings. As far as the possession of firearms or weapons, you must surrender them to law enforcement within 24 hours of your release. Thank you, sir. Madam Clerk, I'm probably not going to remember to say. Yeah, I did. I covered it at the beginning. Montrella Trez Mitchell, case number 2021 CF 13253AO. Aggravated battery with assault with a deadly weapon. The court finds probable cause for that charge. Bond is set at $3,500. $3,500. As to count two, domestic violence, bond is set at $500. The court will order that you not return to the location where this incident occurred, that you have no contact with the victim whatsoever, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of your release. You will be allowed a one-time visit in the presence of law enforcement to obtain personal belongings. Thank you, sir. Vincent Robinson. Mr. Robinson? Yes, the court, case number 2021 CF 13264AO. The court finds probable cause for the count one, only count aggravated battery. The court sets a bond in this case at $500 and orders that you not return to the home. The court is ordering that you have no contact whatsoever with the victim, not possess any weapons or firearms as a condition of bond, and surrender all firearms and weapons to law enforcement within 24 hours of release. Daniel Michael Thompson, case number 2021 CF 13257AO. Do we reset it for the next day when they're in medical, or a couple days?
No, Your Honor, I will waive the appearance,
All right,
in this case.
all right. Counsel for the public defender is waiving appearance. Bond is, the court finds probable cause. Bond is set at $2,500 on count one, 500 on count 2, and the court is ordering no contact whatsoever with the victim, not return to the location where this incident occurred. The court is further ordering possession of no weapons or firearms and to surrender any weapons or firearms as a condition of bond within 24 hours of release. Hanane Ayad, 2021 MM. Okay. Do we want to reset this one?
No, Your Honor, I'm sorry. I will waive the appearance.
All
Have
right.
a victim present?
At this time, based upon a waiver of appearance, the court, did I say the case number on that one? I would do it.
I believe.
2021 MM 675 AW, Hanane Ayad. The defense has waived appearance. Court will, all right.
Hello?
State, do you want to inquire?
Yes, Your Honor. Good morning, ma'am. Can you say your first and last name?
Huda Noor.
I'm sorry?
Huda Noor.
Can you spell your last name for the record?
N-O-R.
She already sworn in?
No, she's not been sworn in, Your Honor.
Raise your right hand, please. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Ms. Noor, how do you know the defendant, Mr. Ayad?
She's my friend. A friend?
Okay. Do you live together?
No.
What is the domestic relationship that you have?
But we just, there's no domestic relationship.
You've not been in a romantic relationship for 4 years?
No, ma'am.
Has something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
Yes, ma'am.
Which one? Was it drugs or alcohol?
Alcohol.
Are you afraid of him?
Her?
Oh, I apologize. Are you afraid of her?
No, ma'am.
And while this case is pending, would you like to have contact with her?
Yes, ma'am.
I have no further questions, Your Honor.
Your Honor, defense has no questions. However, based on the victim's testimony, we would ask for a non-hostile contact order.
All right, the court declines that request. At this time, the court will set bond at $500, order no contact whatsoever. The defendant is allowed 24 hours, within 24 hours of release to retrieve any personal belongings. Defendant must possess no firearms or weapons and surrender any firearms or weapons to law enforcement as a condition of bond. Marcellus Coleman. Is this a witness for Marcellus Coleman? Yes, no, maybe, not? Okay, Marcellus Coleman, court finds probable cause in this case.
Raise your right hand, please. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please announce your name for the record and spell your last name.
Rodnisha Davis, Davis.
Good morning, Ms. Davis. Can you tell me how you know the defendant?
He's my boyfriend for 2 years.
Has something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
No, ma'am.
Are you afraid of him?
No, ma'am.
While this case is pending, would you like to have contact with him?
Yes.
I have no further questions, Your Honor.
No questions.
The court will order pretrial release as to this case. The defendant is ordered to have no hostile contact with the victim and surrender any firearms or weapons to law enforcement within 24 hours of release.
Your Honor, may we approach for one moment, please?
Who's asking to approach? The state?
Yes.
All right.
Thank you.
And Ms. Eugene is asking to approach, so Ms. Eugene and Ms. George can both approach. This is not a dangerous crime. This is a misdemeanor battery. I'm just going to do the pretrial release in this case. Oh, this is one of the listed offenses in 90. Okay, well, I guess I'll look at the statute and I'll see. All right. Can I see the paperwork on that one? The one we just did? Can I have it back? I forgot his last name, sorry.
Coleman.
Coleman.
And Your Honor, my client is okay with the $500 bond.
Oh, he is?
As opposed to pretrial release, yes, Your Honor.
No. Pretrial release is going to be ordered.
Okay.
So, but if is he okay with the $500 bond? Because if he is, then I'm not going to waste time looking at the statute.
Okay,
All right, then I'll do PTR and a $500 bond. Actually, I'll reduce the bond, $250. PTR and a $250 bond with all other conditions. I still need to look at the statute though, because there were a few others that I was gonna do PTR on, so actually, give me one moment.
Specifically, Your Honor, it's number 18, so you don't have to look through the entire thing,
Thank you.
I believe.
I'm pulling up my Florida statutes right now, just give me one moment. It won't take but a minute. 7041. 7041, 4A 18. Okay, yes, domestic violence is included in the list. All right, counsel, you're correct. Domestic violence is included in the list. Let me just be sure that it includes misdemeanor domestic violence. Yes, it does. Okay, thank you, counsel.
Thank you.
Okay, Brandon James Corbett.
And Your Honor, I had a PC challenge for Mr. Corbett
Yes, ma'am.
on the assault, domestic violence.
Yes, ma'am.
I would argue that there is no assault here. Based on the four corners of this arrest affidavit, there is no overt act made towards the victim. Made towards the victim. The defendant gets up when she tells him to leave, and he's digging in his bag. But other than that, there's nothing in this arrest affidavit that would state that he was threatening her or going to harm her.
Well, I don't know. I found probable cause. I don't have the actual paperwork in front of me. Can I see it again? And state, while I'm re-looking at the paperwork, what says the state?
Your Honor, the affidavit is very confusing, but I believe based on Mr. Corbett's history, he has 3 other offenses that are pending. One of them is battery on a Leo, and he has competency issues with all of those cases. I believe the victim is aware of Mr. Corbett's mental health status, as it also lists in the affidavit that he was Baker acted. I believe that she was in fear based on his aggressive behavior.
So I read here and reread that Corbett, Goff stood up, walked over to Corbett, and stated he was going to knock his head off.
That's the victim, Your Honor.
Oh, maybe I got it backwards.
The victim states that.
Okay. And is that the extent of this incident and all these other incidents are related incidents?
So, yes, you have 2 different stories, and then he states that Mr. Goffrey was Baker acted, but when telling Miss Goffrey states that my client Corbett was Baker acted, that he was in the house, she told him to get off of his bed, he went into the living room, The only thing was that she said.
Wait a minute, when Goff was Baker acted, that's a totally different situation.
Yes, Your Honor, that was a
Okay.
different day.
So the facts of the date of this happening,
No, hold on. Let me talk. You gotta give me a second. My client was Baker acted the day before, so she's explaining what happened the day before. He was Baker acted. He shows back up after being
so
released.
there was a knife involved. Was that the day before, or was that the day of?
The day before, Your Honor.
Okay, Corbett started to dig in his backpack. Goff believed Corbett may be retrieving a knife. Was that the day of or the day before? State,
This is the day of.
I want the state to tell me.
Oh, okay.
Digging in the backpack, Your Honor, was the day before. They list the knife as the basis of the victim's fear. So
Okay.
the incident with the knife happened the day before.
So there was no knife that was actually seen the day of this incident.
Per the affidavit, no, Your Honor.
All right. So her fear was because of something that happened the day before, that there was a knife.
Yes, Your Honor.
I still find probable cause. Court does find probable cause. Bond is set at $500. The defendant shall have no contact whatsoever with the victim, not return to the victim's residence, possess no firearms or weapons, and surrender any firearms or weapons within 24 hours of a release to law enforcement.
He can't see, he's really disabled. Your Honor, I would just ask that you take no action on the out on bond. He is in competency proceedings in all of his cases. So I just ask that you not take any action on the out on.
The out on bond cases that the court agrees to take no action on are the non-battery cases. As far as there's one case that's a battery, is the victim a law enforcement officer, or is the victim in this case? State?
No, it's the law enforcement officer, Your Honor.
All right, okay, then I will agree. Court will take no action on the other cases, out on bond cases. Thank you, ma'am. Ryan Patrick Cully.
Call the number.
All right, Mr. Cully. The court does find probable cause in your case for battery domestic violence. The court will order a bond in the amount of $500. And I order that you not return to the location where this incident occurred and have no contact whatsoever with the victim, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you, sir. Jaleel Tyree James. Is there a witness on Mr. James' case coming forward? All right, there's a witness. Mr. James, the court does find probable cause in your case. Let's swear in that witness.
Again, please, you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Mercedes,
Please state your name for the record and spell your last name.
Dickson.
Ma'am, what is your name?
Mercedes Dixon.
Did you say Dixon?
Yeah.
You can put your hand down. Good morning, Ms. Dixon. How do you know the defendant?
Relationship boyfriend.
Has something like this happened before?
No.
Were drugs or alcohol involved in this incident?
No, miss.
Are you afraid of him?
No.
While this case is pending, would you like to have contact with him?
Yes, miss.
Have any further questions, Your Honor?
All right, at this time, the court has found probable cause. The court will order pretrial release as well as a bond of $500. And actually, the court will reduce the bond to $250. And the court will order the defendant have no hostile contact with the victim, and that the defendant possess no firearms or weapons. The defendant must surrender any firearms or weapons to law enforcement within 24 hours of release. Stephanie Michelle, thank you, sir. Stephanie Michelle Jones.
Yes, ma'am.
Ms. Jones, the court finds probable cause in your case for battery domestic violence, and the court will order that you post a bond in the amount of $500, that you have no contact whatsoever with the victim, not return, no contact whatsoever with the victim. Um, Does anyone know whether they were living at that motel in this case, or if that's just the location where this happened?
Your Honor, my client states she does live there. No, he doesn't. That's her address.
So the court will order as follows: no contact whatsoever with the victim, as if the victim is residing at the motel, the defendant shall have no contact. And the defendant is allowed to return in the presence of law enforcement to retrieve any personal belongings. Within 24 hours of release, contact law enforcement for that. Possess no weapons or firearms as a condition of the bond.
Thank you.
Naveed Kareem Khan. All right, now, I don't know if I'm going to need some help from the state on this, but my reading of the PC paperwork, I only found probable cause for one resisting and one battery. But he seems to have been charged with 6 counts of resisting and 2 counts of battery.
No objection, Your Honor.
All right, the court finds probable cause for 1 count of resisting an officer without violence. Bond is set at $500. The court will ROR the defendant as to the other 5 counts of resisting an officer without violence. And the court does not find probable cause for those charges. The court does find probable cause for 1 count of battery, and bond is set at $500. And the court does not find probable cause for the 2nd count of battery and will ROR and release the defendant as to that charge. Further, the court will set the following conditions: defendant must have no contact with the victim whatsoever, and the defendant must surrender any firearms or weapons to law enforcement within 24 hours of defendant's release, and the defendant is allowed to return to any shared household to retrieve any personal belongings in the presence of law enforcement. Ana Maria Montero. Ms. Montero, is there a witness? Seems like there is. The court does find probable cause for battery domestic violence. I swear in that witness.
Raise your right hand, please. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
My name is Derek Paul Jr., Paul, Paul.
Good morning, sir.
Good morning.
How do you know the defendant?
This is my girlfriend.
Has something like this happened before?
No,
Were drugs or alcohol involved in this incident?
no,
Are you afraid of her?
no, not at all.
While this case is pending, would you like to have contact with her?
Yes, for the daughter, so she could contact her daughter. This is her first time incarcerated, so yes,
You mentioned her daughter. Do you want to have contact with her?
yes.
Okay, thank you. I have no further questions, Your Honor.
All right, the court will set bond at $500, order no hostile contact with the victim, possess no firearms or weapons as a condition of bond, and surrender any firearms or weapons within 24 hours of release. Brayshawn Neal. Sir, the court finds probable cause for the offense of battery, stating violence, and orders that you have no contact whatsoever with the victim in this case, that you possess no firearms or weapons, surrender any firearms or weapons to law enforcement within 24 hours of release. $500. Richard Daniel Newcomb.
Yes.
The court does find probable cause for battery, domestic violence. There's a witness. Let's swear the witness in.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Please state your name for the record and spell your last name.
Amber Newcomb, Newcomb.
Good morning, ma'am. How do you know the defendant?
He's my brother.
Has something like this happened before?
Absolutely not, never, no.
Do you know if drugs or alcohol were involved in this incident?
No, ma'am.
Are you afraid of him?
No, ma'am. I actually didn't press charges or anything.
Okay.
I'm sorry, I couldn't hear that last comment.
I didn't press charges.
Okay, thank you.
And while this case is pending, would you like to have contact with him?
Absolutely.
I have no further questions, Your Honor.
I have a question. Does anyone else reside in that home other than you and your brother?
My mother and my father.
Okay, thank you. All right, anything else? All right, the court will set bond, as I said, at $500, order no hostile contact with the victim. And further, the court is ordering that you possess no firearms or weapons as a condition of your bond and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you.
Excuse me, Your Honor.
Yes, ma'am.
There was a lot of miscommunication with the officer. Where would I speak to someone about that?
So the defendant was appointed to be represented by the public defender's office, and the public defender will have a consultation with the defendant, and they will be able to determine how they need to proceed forward, including talking to the victim or any other witnesses that may be involved.
Okay, thank you.
All right, thank you. Jacob Edward Schaefer. Mr. Schaefer, the court does find probable cause for battery, dating, violence, and orders a bond of $500, or that you not return to the location where this incident occurred, with the exception of one time in the presence of law enforcement to retrieve any personal belongings. You must have no contact with the victim, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of your release. Thank you, sir. Clayton Raycliffe Wren. Mr. Wren, the court finds probable cause for battery, dating, violence, and orders that you post a bond in the amount of $500, that you have no contact whatsoever with the victim, possess no firearms or weapons, and surrender any firearms or weapons to law enforcement within 24 hours of your release.
Your Honor, I apologize for breaking in. One of the previous cases, Brashawn Neal,
Yes, ma'am.
there was a victim present.
Oh, I'm sorry.
If they have the right to be heard, so I just.
Yes, of course. We can have the victim come forward right now.
Do you need Mr. Neal back, Your Honor?
Yes, yes, absolutely. I will surrender any weapons within 6 hours of release as to Mr. Wren. I see the Brashawn. What was Brashawn's last name?
Neal, N-E-A-L.
Mr. Neal's
It's
paperwork.
case number
Neal.
21MM
Can we bring the witness into the witness box, please?
7136.
Is there a problem getting the witness into the witness box? Okay. Let's swear in this person.
Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name for the record and spell your last name.
All right, my name is Kayvon Ratliff. Ratliff as in Ratliff.
All right, thank you, Mr. Ratliff. We're trying to get Mr. Neal back, and then we'll, let's just wait.
Yes, Your Honor.
We're going to get Mr. Neal back, and then we'll have some questions for you, okay?
Okay.
unless the defense wants to waive Mr. Neal's presence.
Oh,
Well, how,
are you,
you all move pretty fast. Y'all got him out of here fast. I thought he was just right out there.
Yeah, Your Honor, you was like.
I know. I know. Yeah, I guess we all are moving pretty fast today. Okay, that's fine. We'll wait, and he'll be right back.
While we wait, can you repeat the conditions for Mr. Wren? He was the last defendant that was heard. 21 MM 6603. Just the conditions, please.
okay. He's downstairs.
Bond was set at $500, no contact whatsoever with the victim. Possess no firearms or weapons and surrender any firearms or weapons within 6 hours of release. Those were the conditions.
Thank you, Your Honor.
All right, Mr. Neal, there was a witness, and Mr. Ratcliffe is sworn in already, and we will take testimony. Go ahead.
Good morning, sir. How do you know the defendant?
We're half and half together.
Okay. Has something like this happened before?
No, ma'am.
Do you know if drugs or alcohol were involved in this incident?
We had just left Buffalo Wild Wings, but it wasn't a lot consumed.
Okay. Are you afraid of him?
I'm not afraid of him.
And while this case is pending, would you like to have contact with him?
That's fine. I don't feel like my life is in danger. I just honestly feel like,
I couldn't hear the last thing you said. After you said you don't feel like your life is in danger, you said something else. What was that?
I honestly feel that it was like a mental breakdown. I don't, that's the only thing I can really tell.
Are you from this area?
No, ma'am.
Where are you from?
Mississippi?
Is the defendant also from Mississippi?
Yes, ma'am.
Are you moving here or just vacationing?
Just vacationing
When do you expect to return to Mississippi?
on Sunday.
I have no
Or
further
probably
questions.
sooner.
I have no further questions, Your Honor.
Okay, thank you.
No question, Your Honor.
All right, I do want to just clarify. Are you comfortable having contact with Mr. Neal?
Yes, ma'am. This hasn't happened before.
All right. Are you over the age of 18?
Yes, ma'am. I'm 23 years old.
Okay. The court will amend the order to no hostile contact. No hostile contact. And the bond remains set as the court initially stated, $500. All right, thank you.
Okay, no problem.
Cassandra Jean Helms, that's not Cassandra, I don't think. Ramon Luis Figueroa Rodriguez. All right, is that who he is, though? Figueroa Rodriguez? Okay. Oh, wait a minute, I forgot to do the case numbers. Yeah, I haven't been doing case numbers. Gotta remind me, I forget. Mr. Figueroa Rodriguez, case number 2021 CF 2735, Osceola County. Is the interpreter on the line?
Yes, Your Honor. Can you hear the interpreter?
I can hear the interpreter. Now let's be sure that the defendant can hear the interpreter, and then we can proceed.
Can you hear me, Your Honor? Your Honor, he can hear me.
Ms. Interpreter, can the defendant hear you?
Yes, Your Honor, he can hear
All right, sir, you were picked up on an out-of-county warrant, Osceola County, and the court will order the bond as to count one. remain at no bond. Count 2, remain at no bond. Count 3, remain at $2,500. Count 4, remain at no bond. Count 5, remain at no bond. Count 6, remain at $1,500 bond. Thank you, sir. The court has appointed the public defender to represent you in this case.
Tengo una pregunta para ella.
I have a question.
Ms. Interpreter, I would just advise the client not to talk about the facts of the case.
No, yo no estoy hablando nada de los hechos, simplemente
Sir, what's your question?
A ver,
que yo no quiero public defender, yo tengo abogado. Eso es todo.
I just wanted to say that I don't want a public defender because I already have an attorney.
All right, then the court will release the public defender. Public defender does not represent you in this case.
Entonces, lo último que te pregunto son, no tengo, para los otros casos, no puedo tener fianza para poder fiarme.
My other question is regarding those cases, I don't have any bonds on those.
You will need to communicate with your attorney about any specific questions regarding those cases. The bonds where I announced there was no bond is because that was the bond that was set in Seminole County. I can't change it. Then the bonds, the two where there was a $2,500 bond and a $1,500 bond, those were set also by the judges in Seminole County. I cannot change them.
Is it Seminole or Osceola?
Oh, I'm sorry, I misspoke. It's Osceola? Osceola County rather than Seminole County. That was my mistake, sorry. Thank you, sir. Cassandra Jean Helms, Ms. Helms? Yeah. Ma'am, you also were picked up on an outer county warrant, and it is Osceola County. Ma'am, bond will stay set at no bond as to that case. Thank you, ma'am. Oh, the court did appoint the public defender in your case, ma'am. I am not hearing you at all. You got to come to that microphone.
Am I gonna be sent back to Osceola County?
Oh, yes, ma'am. You will be sent back to Osceola County eventually. Yes, ma'am.
Okay. I thank you.
Thank you, too. Michael Sean Kornikowski,
Your Honor, is the attorney.
case number 2021 CT 9613 SC, Kornikowski, Sarasota County. Mr. Kornikowski, sir, you were picked up on a out-of-county warrant for bond was set at $500 in that out-of-county, and bond will remain set at $500 for this case.
Your Honor, bond was paid last night, so I'm not sure what the next process is.
Neither am I.
I don't see that the bond was paid.
Well, let me ask you this. I gave the bail bondsman, which didn't sound too organized, 3 numbers. My debit card is in, I guess, in the locker. I have the funds to pay it myself. How can I go about doing so? I have the money to pay downstairs, but my...
When you go down, you gotta let them know.
Okay. How do I get downstairs to do all this? Yeah. Where are they going? I'm not even sure of this whole, I'm really confused.
No. Demian DeAndre Matthews, sir, you were picked up for a violation of probation, and bond will remain set at no bond as to your violation of probation. Thank you, sir.
Thank you.
Abimelech Ortiz Rivera. Mr. Ortiz Rivera, you were picked up for violation of your probation. Bond will remain set at no bond as to your violation of, I'm sorry, is this Mr. Ortiz Rivera? No?
This is Nieves.
Okay.
Yes.
What's his first name? Last name?
Homie.
Nieves.
We don't have that paperwork. no. I don't think I even read that one this morning. And if I did, I don't see. No bond. All right, Jaime Daniels Nieves Janez, case numbers not on here, or,
Gotta go there.
okay, that's it. 2020 CF 630880. Sir, you're picked up for violation of your probation, and bond will remain set at no bond for this violation of probation. Thank you, sir. Abimelech Ortiz Rivera. Mr. Ortiz Rivera, as to your violation of probation, bond will remain set at no bond. Thank you, sir.
Hold on. Can I speak with you, Judge?
I did appoint the public defender to represent you in your case, sir. Cesar Zabala Auli. All right, reset that for Saturday, tomorrow, 24 hours.
Your Honor, he would still like to ask you a question.
Please, Your Honor, help me. I got one job and I'm about to lose it. I'm taking care of my family. It's just me.
There's nothing I can do, sir. You're gonna have to have your lawyer file a motion with the judge that set the bond at no bond.
Which judge is that?
Your attorney will tell you who that is.
All right.
Samuel Hunter. All right, we'll reset that for tomorrow, Saturday. Jelvis Javier RZ Lazardi Baez. Okay, Mr. Lazardi Baez. Yes, sir, the court, you were picked up on your violation of probation. The court will, bond will remain at no bond.
May I speak, Your Honor, please?
So I did appoint the public defender to represent you on this case. I don't have any other cases. Court's going to take a 15-minute recess. Actually, I'm going to take a 30-minute recess. Ms. George, did you have something? Ms. George?
No.
All right, thank you, Ms. George. How many cases are there this afternoon? Not this afternoon, because I'm not going to wait until this afternoon. I'm going to start when I finish.
Thank you, Your Honor.
Your Honor, Your Honor,
Mm-hmm.
I would like to speak on my behalf, please, and thank you.
Ms. George said that there
I
was
advised against Your Honor, however, he still would like to speak.
All right, sir. I will more than likely refer you to your attorney, but let me just hear what you have to say, okay?
The whole reason I got picked up
Mhm.
was because of a FTA in Seminole County. I signed my waiver to appearance for my court date over there. My public defender forgot to turn it in to the judge. So my public defender and bondsman already reinstated my bond, and it's a court-signed document by the judge and by the public defender that this was their mistake. I shouldn't have no violation. I shouldn't be in jail. I was falsely arrested. I was supposed to get released yesterday until you guys hit me with the violation.
There is absolutely nothing that I can do that is better than what your lawyer is going to do for you. So there's nothing I can do. Okay.
Are we in recess now?
Mm-hmm. How many for this afternoon?
We're in recess until 11:15?
How many? 4-0? I'll ask Teresa. How many there are would determine how long.
My life now.
Oh, I still can hear the accent.
It comes and goes, more goes.
Mr. Eugene? I'm sorry, Mr. Adams? Mr. Adams? Hi. Sir, you're charged with loitering or prowling, and I do find probable cause, and I am staying the bond at $500. Thank you, sir. Thank you, sir.
Your Honor, would you do a no return to the area?
I sure will, and the court is further ordering that you not return to the location and the area where this occurred. Thank you, sir. Cornelius Brodus?
He's mental health, Your Honor.
Does the public defender wish to waive his appearance and for me to proceed, or shall I reset this for,
He does have an offer, Your Honor, so I would just ask for you to reset it for tomorrow. Maybe he could plea it out.
all right, case will be reset for Saturday in the morning. Erica Taylor? Mm-hmm. Ms. Taylor? Ma'am, the court does find probable cause for your charge of trespass. Bond will stay set at $500, and you are ordered to not return to the location where this incident occurred.
Your Honor,
Mhm.
given that she has no criminal history,
Mhm.
there was an offer to resolve, but I don't see any criminal history, so I would ask for an ROR. If you're not inclined to do an ROR, I would ask that she be at least interviewed for pretrial release to see if she would qualify, because I don't believe they had a chance to interview her.
I see that she does not qualify for PTR. I would not be willing to grant an ROR, but I would be willing to reduce the bond.
Yes, Your Honor. Yes, Your Honor, reduce the bond, please.
All right, the court will reduce the bond. Rather than $500, bond will be $150. Amber Rose Willery. Refused? All right.
And I will waive the appearance, Your Honor.
All right, this case will be rescheduled for in the morning. She did not waive.
Oh, no, I'll waive the appearance, Your
Oh,
Honor.
you did waive? I'm
Yes.
sorry, I misheard you. I thought you said I will not waive.
No.
Okay, at this time, the court does find as follows. The probable cause for 2021 CF 132441AO, bond is set at $1,000, and bond is stated at $2,500 in 2021 CF 4302AO for failure to appear. I'll try to remember to do case numbers. Carlos Eduardo Vega. All right, Mr. Vega, this is case number 2018 CF 17703AO.
Good morning.
Is this Mr. Vega?
Afternoon.
Good afternoon, Mr. Vega. The court is staying the bonds at no bond in your case for both counts. Thank you, sir.
What both counts?
Yes, sir, for failure to appear, and I did appoint the public defender to represent you, so if you need more information about the charges, the public defender can provide it.
So I don't get no bond whatsoever until this case is done?
Well, not until the case is done, you just get no bond at this time, all right?
Okay. How about if it was just to plea out?
Now, that's something you have to talk to your lawyer about. I did appoint the public defender.
There you go.
Oh, yeah?
Yes.
So I can talk to her right now?
Well, I think she has other cases that she has to be ready on, but the public,
They don't answer that. I mean, I'm gonna be in jail and I'm not gonna have no bond, so how am I supposed to get in contact with them?
they have their,
Answering no papers.
they have their means of getting in contact with you, sir, but I do have the other defendant right behind you, and I need to go ahead and go to his case now.
Okay, so I'm not important?
Thank you, sir. I have the next case that I want to call. Johan Alejandro Jimenez Garcia. Johan Garcia. The court finds probable cause for trespass on property after a warning.
And Your Honor, the state did give Mr. Jimenez a offer of a withhold of adjudication, credit time served, and no return to, I believe it's Home Suites located at 12350 East Colonial Drive. I did go over all the rights he would be given up. He understands those rights, and he would like to accept the plea.
All right, now he's been sworn in.
No, Your Honor.
Swear to tell the truth, whole truth, and nothing but the truth, help you God?
I do.
How do you wish to enter your plea to the offense of trespass on property after warning? Guilty, not guilty, or no contest?
No contest, ma'am.
May I see the plea form?
We don't have them signed until they come in here.
Oh, that's fine. Mr. Jimenez Garcia, did you read this plea form that's being handed to me, sir? Did you read this document? No?
No, we went over it. I didn't.
No, did the attorney go over the rights that you're giving up on this document? Do you understand the rights?
Yeah, with her? Yes.
Yeah, okay, sir, let's start all over again here now because I cannot take a plea if I don't feel that you understand what you are doing. So
I did, okay.
I'm going to start over. First of all, do you speak English, sir?
Yes, ma'am.
And do you speak it fluently?
Yes, ma'am.
Okay, was there any kind of language barrier between you and the young lady who's standing next to you who is a lawyer when you talked to her?
No.
Okay. Did she explain to you what would happen to you if you entered a plea of no contest to this case? Did she explain that you would be sentenced and the judge would impose a sentence today?
Yes, she said, yeah.
She did? And did she tell you that you would be giving up the rights on this form, such as the right to go to trial, the right to have a lawyer represent you at the trial, the right to have witnesses called to testify at the trial, and those additional rights if you entered this plea of no contest? Did she tell you all that?
Yes, yes, ma'am.
Are you under the influence of any alcohol or drugs or medicine this morning?
No, ma'am.
Do you understand a conviction on this case will subject you to being deported if you are not a United States citizen?
I understand, yes, ma'am.
All right, the court does find that there is a sufficient factual basis to accept your plea, and I find that you are alert, you are intelligent. I'll withhold adjudication of guilt. Time served.
2 days.
Order 2 days with credit for 2 days. Time served. Order that you not return to the home suites where this incident occurred. State to provide the address for the record.
12350 East Colonial Drive, Orlando.
Thank you, ma'am. Sir, do you have any questions?
Your Honor, I would just ask that you give him a one-time return to get his bags. Yes, he was staying there with law enforcement to collect his baggage.
Well, I don't know if the baggage will be there, but I will order that. Sir, I will allow you a one-time visit in the presence of law enforcement to retrieve any personal belongings that might still be in the premises. However, we don't know where they are at this time. You understand?
Yes, I understand.
I also am going to put you on a payment plan to pay your court costs that I'm ordering in this case. The court costs must be paid through the clerk's office at $20 minimum per month until paid in full. First payment is due within 90 days of your release from incarceration. I am releasing you as to this charge. Thank you, sir. You can exit for your paperwork.
Thank you, Judge.
You might see Jimenez.
He bonded, Your Honor.
All right, previously bonded.
He-
They bonded. Robert Lynn Washburn.
He's in the hospital.
They're in the hospital. Case will be reset when the defendant is out of the hospital. Reset it for tomorrow, actually. Robert Joseph Culver.
Right here.
Mr. Culver, the court does find probable cause for possession of an alcoholic beverage, open container, in case number 2021 MO 1160AO.
And, Your Honor, the offer from the state was a withhold of adjudication, credit time served. I did speak to Mr. Culver. We went over all the rights he would be given up. He understands those rights and would like to accept the offer.
All right, and Mr. Culver, how will you like to enter your plea to this charge? Guilty, not guilty, or no contest?
No contest, Your Honor.
All right, may I see the plea form? All right, sir, did you read that plea form that I just saw you signing?
Yes, ma'am.
Did you have any questions about anything contained on this document?
No, Your
You
Honor.
understand you're giving up the rights on this document by entering this plea of no contest?
Yes, Your Honor.
Are you under the influence of any alcohol, drugs, and medicine today?
No, Your
You
Honor.
understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, Your Honor.
All right, sir, there is a sufficient factual basis. You're alert, you're intelligent. I'll withhold adjudication of guilt or you to pay mandatory court costs through the clerk's payment program at $20 minimum per month until paid in full. Your first payment is due within 90 days of your release from incarceration. I am ordering your release as to this charge. Do you have any questions?
No, Your Honor.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. John Robert Faylor. Mr. Faylor, this is case number 2021 MO 1161AO, disorderly conduct. Court does find probable cause.
And Your Honor, the state is offering a withhold of adjudication, credit time served. I did go over all the rights of Mr. Taylor that he will be given up, understands those rights, and would like to accept them.
All right, Mr. Faylor, how do you wish to enter your plea to this charge? Guilty, not guilty, or no contest, sir? All right. Has he signed the plea form? All right, Mr. Faylor, I see that you are signing the plea form. Did you read that document, sir?
Yes.
All right. Was your attorney able to answer any and all questions you had regarding this plea to your satisfaction, sir?
Yes, ma'am.
Are you under the influence of any alcohol or drugs and medicine at this time?
I do not drink or do any alcohol.
Okay, do you understand that a conviction on this case will subject you to being deported if you're not a U.S. citizen?
Yes.
You understand that, Mr. Faylor?
Yes.
All right, sir, there is a sufficient factual basis, and you are alert, you're intelligent. I'll withhold adjudication of guilt, order mandatory court costs, and credit for time served. Sir, the court costs must be paid through the clerk's payment program at $20 minimum per month until paid in full. The first payment is due no later than 90 days from your release from incarceration. Of course, I am releasing you as to this charge. Any questions? You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Kelly Eugene Gibbs. Kelly Gibbs. You're charged in case number 2021 MO 1162AO with disorderly conduct.
The state is offering a withhold of adjudication, credit time served, but I did not have a chance to see Mr. Gibbs, if I just have just a second.
All right.
Your Honor, I did briefly go over the rights he would be given up. Mr. Gibbs stated he understands those rights and would like to accept the state's offer. However, he would ask that you, waive, well, not waive, but I guess, what is it, default, or put a lien on the court costs, Your Honor, I'm sorry, for his court costs as he does not have any money and is currently homeless.
What says the state?
I don't have any objection, Your Honor.
Mr. Gibbs, how do you wish to enter your plea? Guilty, not guilty, or no contest?
No contest.
All right, sir. Are you going to sign that plea form, sir? And can you repeat the offer, ma'am?
It's a withhold of adjudication, Your Honor, credit time served.
Okay. Mr. Gibbs, is this your signature? Well, I just saw you sign it, sorry. Did you read this plea form before you signed it, or your attorney go over it with you before you signed it?
Yes.
Did you understand that you are giving up all the rights that are on the front of that plea form by entering your plea of no contest? Yes or no?
Yes.
And was your attorney able to answer all of your questions to your satisfaction regarding this hearing and this plea today?
Yes.
Do you understand that a conviction on this case will subject you to deportation if you're not a U.S. citizen? The court finds there is a sufficient factual basis. You are alert, you're intelligent. I will withhold adjudication of guilt, order mandatory court costs, order credit for time served. As to the court costs, I'll reduce it to a civil judgment. Do you have any questions?
No.
You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. You may exit for your paperwork. Dennis Hoover. Case number 2021-MO1163AO. Mr. Hoover, the court finds probable cause for the offense of disorderly conduct. I would set bond at $250.
I'm sorry. The state is making an offer of a withhold of adjudication, credit time served. I did go over with Mr. Hoover, the rights will be given up, and those rights would like to accept the state's offer.
All right. Sir, how do you wish to enter your plea? Guilty, not guilty, or no contest?
Contest?
Are we not swearing people in today? Okay.
Raise your right hand, please. You swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Thank you. All right, sir, is this your, I saw you sign it, sorry. Did you read this plea form or have your attorney read it to you or go over it with you before you signed it?
Yes, ma'am.
And did you have any questions about anything contained on this document?
Oh, ma'am.
Was your attorney able to answer all of your questions to your satisfaction?
Yes, ma'am.
Are you under the influence of any alcohol, drugs, or medicine today?
Oh, ma'am.
You do understand you are giving up all the rights by entering your plea of no contest, all the rights on that plea form?
Ma'am.
And do you understand that a conviction on this case will subject you to deportation if you are not a U.S. citizen?
Yes, ma'am.
All right, there is a sufficient factual basis. You are alert, you're intelligent. I will withhold adjudication of guilt, order mandatory court costs, and order credit for time served, court costs to be paid through the clerk's payment program at a minimum of $20 per month until paid in full. Your first installment is due no later than 90 days from your release from incarceration, and I am ordering your release as to this charge. Thank you, sir. You have the right to appeal this sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. This thing moves. Need it to not move. Eldred Smith. All right, Mr. Smith, I find probable cause for the offense of disorderly conduct in case number 2021-MO1164AO.
And Your Honor, the state is offering a withhold of adjudication, credit time served. In order to resolve the case today, I did speak with Mr. Smith, went over all the rights he would be given up, understands those rights, and would like to accept the state's offer.
Mr. Smith, sir. Yeah, go ahead. Go ahead, Madam
You swear to
Clerk.
tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Mr. Smith, I think I saw you sign this. Did you sign this plea form?
Yes,
And
ma'am.
how do you wish to enter your plea? Guilty, not guilty, or no contest?
No contest.
Did you read this plea form, or did your attorney go over all these rights in your presence regarding your plea today? Was your attorney able to answer all of your questions to your satisfaction, sir?
Yes, ma'am.
Do you understand that you are giving up all the rights on this plea form by entering your plea of no contest?
Yes, ma'am.
Yes or no?
Yes.
And are you under the influence of any alcohol, drugs, or medicine, sir?
No, ma'am.
Do you understand a conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
There is a sufficient factual basis, sir. In your case, you're alert, you're intelligent. I will withhold adjudication of guilt and order mandatory court costs, order you be awarded any credit for time served. All monies must be paid through the clerk's payment program at a minimum of $20 per month until you pay it off. The first payment is due within 90 days of your release from incarceration. I am ordering your release as to this charge. You do have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Do you have any questions?
No, ma'am.
All right, thank you, sir. Razwan Gombe Jones. Mr. Jones, you were picked up in case 2020 CT 3900AO for failure to appear. Bond will stay set at $2,000 in that case.
Sorry, Your Honor, the state is offering an adjudication of guilt, credit time served to resolve the case today. I did speak to Mr. Jones. We went over all the rights he would be giving up. He understands those rights. We also talked about the fact that this charge can be enhanced at a later date. He understands all of those
The
rights.
charge is operating a motor vehicle without a valid driver's license?
I was thinking about driving while license suspended.
Okay.
But I did speak to him about all the rights he'd be giving up. He understands those rights and would like to accept the offer.
So it is uncertain as to what he is charged with, now that you mention it, because the statute is different. The statute is the failure to appear statute. The charge is operating a motor vehicle without a valid driver's license. Is the state dismissing the failure to appear if he pleads to the no valid?
Yes, Your Honor, we're only going forward on the no valid.
Okay, all right, that's fine. Can you repeat the terms of the agreement again?
An adjudication of guilt, credit time served, Your Honor.
All right. Mr. Jones, raise your right hand to be sworn in. Do you swear that the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Aye.
All right, Mr. Jones, did you sign that plea form? I think I saw you signing something. Is that what it is?
Yes.
Did you read this document, or did your attorney read it for you and explain it to you, sir?
Yes.
Did you have any questions, or were all of your questions answered to your satisfaction by your lawyer?
Yes, ma'am.
Sir, are you under the influence of any alcohol or drugs or medicine this morning?
No.
This afternoon? Do you understand that a conviction on this case will subject you to being deported if you are not a U.S. citizen?
Correct.
There is a sufficient factual basis. You are alert, you're intelligent. I will adjudicate you guilty, order credit for time served and mandatory court costs to be paid through the clerk's payment program at a minimum of $20 per month until paid in full. Your first payment is due within 90 days of your release. I am releasing you as to this charge, dismissing the failure to appear. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Thank you, sir. You may exit for your paperwork.
That's what
Dinesh Shetty. Case number 2021 CT 6793. Driving under the influence, the court does find probable cause. Bond is set at $500. 2021 MM 7141 AO. Possession of paraphernalia. The court does find probable cause. Reduce bond from $500 to $100. Thank you, sir.
Thank you.
Amanda Victoria Via. Ms. Via, in case number 2021 CT 5648 AO, you failed to appear. Bond is stayed at $2,000.
I'm sorry, Your Honor. The state is also making an offer to resolve the no valid
Yes,
driver's
ma'am.
license, with an adjudication of guilt, credit time served. I did speak to Mrs. Villa. We went over all the rights she'd be giving up. She understands those rights and would like to accept the state's offer today.
All right, Mrs. Villa, how do you wish to enter your plea? Guilty, not guilty, or no contest?
No contest.
And do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
Yes, ma'am.
Is this your signature here at the bottom of this plea form?
Yes, ma'am.
Did you read this form, or did your attorney read it and explain it to you?
Yes, ma'am.
Did you have any questions, or I should ask, are you satisfied with all of your questions being answered by your attorney?
Yes, I am.
Are you under the influence of any alcohol or drugs and medicine? Do you understand that conviction on this case will subject you to deportation if you're not a U.S. citizen?
Yes, ma'am.
All right, there's a sufficient factual basis. You're alert, you're intelligent. The court will adjudicate you guilty, order credit for time served and mandatory court costs to be paid through the clerk's payment program at $20 minimum per month until paid off. The first installment is due within 90 days of your release from incarceration, and I am releasing you as to this charge. The court will dismiss the failure to appear. You have the right to appeal the sentence. If you wish to appeal, you must do so in writing within 30 days of today's date. Any questions?
No, ma'am.
Thank you. You may exit for your paperwork.
Thank you.
Walter George Adams.
He's coming, Your Honor.
Thank you. Case number 2020 CF 10880AO. Walter Adams. Mr. Adams, the court finds as follows. Bond will stay set at $2,000 for failure to appear on count 1, 100 for failure to appear on count 2, 100 for failure to appear on count 3. As to 2021 CT 6794AO for the driving while license suspended.
I'm up under my own government. I am my own.
Court will set bond at $2,500.
This is not the venue.
2021 MM7145AO. Bond will stay set at
National law.
$500.
You're not
Thank you, sir.
acknowledging the
You're
vehicle
excused.
passport. For the record, I am from the Moorish Science Temple of America. Violation.
John Robert Capurso. Mr. Capurso, in case number 2021 CF 127410. It doesn't say, I guess it's AO. The court finds probable cause. Bond remains set at $4,000. Thank you, sir. Christopher Carr, case number 2021 CF 13263AO. Count 1, bond stays set at $5,000. Count 2, bond stays at $100. Count 3, bond stays at $100. And count 4, bond stays at $100, for which all the court finds probable cause. Since the defendant does qualify for PTR, if the state has no objection, the court will do bond or PTR.
No objection, Your Honor.
All right, sir, if you, I am allowing these bonds to be paid if that's what you prefer to do, but you qualify for PTR. So bond or PTR.
Thank you.
Does he want PTR?
Jabari Davis. Mr. Jabari Davis, it's case number 2020 CF 116050AO. The court finds probable cause and bond stays set at 0 none on the RICO count 1, and on the conspiracy count 2. Thank you, sir. 0, none, no bond. Basim Saeed Deeb, attorney to appear on video, at least that's what I was told.
Ma'am, I'm sorry.
I hear you, but I can't see you. Am I supposed to see him? I can't see you. Can you unmute your video?
I think that was the defendant, Your Honor.
Oh, well, the attorney was. Well, it says attorney will appear virtually. Oh, he isn't waiting? Okay. Did they do it on this phone? Okay. This box, they would be waiting.
Sure, I can't see it.
Welcome to an Econo meeting. You are entering the meeting now.
This is Judge Allen at the BRC. Is legal counsel on the video to represent Basim Saeed Deeb? Legal counsel, are you present to represent Basim Saeed Deeb?
Yes, Your Honor. Philip Arroyo on behalf of Mr. Deeb. Give me 1 second. I'm having some technical difficulties with my screen.
I can hear you and I can see you, so let's go.
Yeah, but I can't see you.
Well, I'm here, I can promise you that. Do you need to see me for us to do this? I think
no,
it's
Your
more
Honor,
important that I see you than that you see me.
that's fine, Your Honor.
Case number 2021 CF 12611AO, count 1, sexual battery on a child under 12. The court finds probable cause, bond stays set at no bond. Count 2, lewd or lascivious molestation, victim under 12, bond stays set at no bond. Counsel?
Your Honor, we would request a reasonable bond in the amount of $10,000. My client has significant ties with the community. He has lived at the property at 309 Penn Avenue, Winter Garden, Florida, 34787, for over 56 years. Not only that, but he has significant ties with the community through 2 businesses that he runs. He runs a flea market. He also owns and runs an electrical business for electrical services. He has 2 daughters and a wife, which he provides for, and he won't be able to do that if he is in custody. He has no prior criminal offenses on his record. And he also, Your Honor, and this is the most concerning aspect, he suffers from numerous health conditions such as diabetes, liver and kidney problems, and heart disease, which poses a great concern now with the COVID situation, and considering he's at risk, not only because of his age, but because of his underlying conditions.
Has he been on dialysis?
Good question, Your Honor. I assume he has, but all I have as of now, because I'm covering for my colleague, Ms. Miranda, is that he does and has been diagnosed with these health conditions. So that's a huge concern for the defense, Your Honor. We don't think that we can assure the court he's not a flight risk. He's willing as well to turn in his passport. The fact that he has been over 56 years in the community at the same residence, I think this court.
So listen to me, I am willing to set a bond, but 10,000 seems pretty low. Let me see what the state has to say.
Understood, Your Honor.
Your Honor, this is a capital offense. This is actually punishable by death because it was sexual battery on a child that was under the age of 12.
Punishable by death?
It's a capital offense, Your Honor. It is a capital offense. One other thing, Your Honor, I believe that he actually does have criminal history. If you can hold for one moment.
Yeah, Your Honor, it shows that he has 6 felonies, 1 misdemeanor, 2 FTAs, which was in 2003, and he has been.
Can you tell me more about the felonies?
Looks like it's a grand theft and forgery, passport.
Okay, do you see any sexual batteries or lewd and lascivious charges?
No sex crimes.
Okay,
Your
and
Honor, if
Ms.
I may,
Eugene,
Your Honor.
no, let's let Ms. Eugene continue.
Okay, understood.
That's the state, no, we're gonna let the state continue.
The other aspect, Your Honor, is the victim was 4 years old at the time that this supposedly happened. So, no, definitely.
But how old is the victim now?
She is,
From my recollection, it happened like 4 years ago or more. So the victim is at least 8 now.
she was 4 or 5 years old. I'm reading again, Your Honor, just to give you that information.
I read it, I just, I know it has not happened in the recent past. It was years ago, according to the PC. And I would just ask the state if there was any indication of anything else happening between that time and the witness.
According to the affidavit, Your Honor, no. But the reason that it happened at that time is because she was attending elementary school, so she would go over to her uncle's home. That's how he was able to gain access to her, Your Honor. But no, there has been nothing since that time.
So just because a case is a capital case doesn't mean a person isn't entitled to bond. So if the state is just going to say it's a capital case, you're not really giving me anything to go on because I am considering a bond in this case. And I hear the defense saying 10,000, and the state's just saying it's a capital case.
Your Honor, we wouldn't even give a $10,000 bond to an F2. I would ask if you are going to use your discretion, I would at least ask for a $100,000 bond, Your Honor. Because you have to also bear in mind the community, as well as whether or not defendant would be a flight risk, and whether or not he would be able to show up. As I mentioned, this is a capital offense, so he has to have incentive to want to come back for trial. And I believe defense did say something about him surrendering his passport. If the court is going to give a bond, I would also ask for that the defendant surrender his passport. But I would ask for at least 100,000, Your Honor.
Anything else?
That he have no unsupervised contact with any minors. He have no contact with the family.
Is that rather broad? Because isn't he related to people that she might be related to?
Yes, Your Honor.
So can we be the victim or the victim's parents or siblings?
Yes, Your Honor. And as I mentioned, also to surrender the passport.
Any other conditions the state would, if the court does grant a bond, any other conditions the state believes are appropriate?
Not at this time, Your Honor.
Okay.
Your Honor, may the defense briefly address the court?
Well, I am actually, yes, you may, but let me just, let me think here. I'm reflecting on some of the things the state has said, and I need time to reflect, please. Yes, sir.
Yes, Your Honor. I would point out to the court and to the state that my client is innocent until proven guilty. It's not the other way around. My client, we've already submitted information establishing that he does have strong ties with the community. He's willing to turn in his passport, and we would ultimately ask for a reasonable bond. We believe 100,000 is excessive. And if an excessive bond is established, it would be tantamount to no bond at all if it's excessive. So we would respectfully request the court for a reasonable bond.
So I have a lawyer asking for 10,000, and the other one saying 100,000, and the lawyer who's asking for 10,000 says that the 100,000 is unreasonable. So basically what you all are doing is you're putting me in a position where I need more information because you're so far apart on what you believe a reasonable bond would be. This is 10,000 is, I think Ms. Eugene mentioned some F2s are what you give a $10,000 bond for. And I'm sorry, it's just, I'm going to need more information to figure out what the appropriate bond should be. Should it be 100,000, 75? Should it be 50,000? We have a person here who I'm concerned about their health conditions. I would be absolutely less concerned about it if we were not in the midst of a COVID pandemic. But when you tell me someone has health conditions to include diabetes, to include liver and kidney disorders, yes, that definitely gets me to the point where I am thinking I want to give this person a bond, give them a chance to get out of a situation where they may wind up sicker because of being arrested on a charge that they are innocent until proven guilty on. But at the same time, I don't know that 100,000 is the correct bond, but I do believe 10,000 is way too low. And so I'm not going to be pulling bonds out of my hat. I need more information. We maybe need a full-blown hearing with the victim present, the victim's parents, maybe need additional information from law enforcement who, or anyone who's taken a statement from the victim so that the court, when the court considers reducing the bond, the court will have all the information the court needs to set a reasonable bond that is appropriate under the facts of this case. So given that I feel that I am lacking in information that will make me comfortable as the judge to set a bond of any amount, you all are so far apart on what you believe a reasonable bond would be. I will, you're the lawyer, you're going to have to go to the judge and set it for a hearing and bring appropriate witnesses and documentation so that the judge will have all the data and information that they need to set the appropriate bond. It would have been my desire to set a bond, but I just don't know what the right bond is in this case. So your client bond stays set at zero bond until we can get a hearing with witnesses, and witnesses can help me set, or any judge, set the appropriate bond.
Your Honor, if I may, we would respectfully request if you'd be willing to reconsider. We would withdraw the suggestion of $10,000 bond and leave it to discretion of the court to whatever bond you deem necessary.
Well, the bond that the state is suggesting is $100,000, of which the court, if I don't have someone asking me and saying 10,000 is a better bond, I'll set it at 100,000. So bond is set at 100,000 on count one. And state, are you asking for the same on count two?
Yes, Your Honor.
And 100,000 on count two. Conditions of bond are as follows. The defendant must surrender his passport within 24 hours of release. The defendant must have no contact whatsoever with the victim, the victim's parents, the victim's siblings, or anyone who resides in the victim's household. The defendant must not well, I guess it happened at the defendant's home and not the victim's home, Ms. Eugene?
Yes, Your Honor.
All right. The defendant must have no contact with any minor under the age of, do you want me to do 18 or?
18, please, Your Honor.
Under the age of 18 without supervised conduct, supervision of an adult over the age of 18. The defendant must possess no weapons or firearms and surrender any weapons or firearms to law enforcement within 24 hours of release. State, have I included all the conditions that you mentioned?
Yes, Your Honor.
I'm going to add one additional condition. The defendant must produce documentation of his health conditions, which can be filed with the request that the court seal the medical records, but they must be produced so that the court and the state, of course, can be confident that the defendant's health conditions are consistent with what counsel has said. Now, counsel, no blemish on you, but we're going by what he says. And I absolutely do not want someone with these types of health conditions over their head incarcerated in the Orange County Jail during a pandemic. But I want some documentation. And the documentation must be provided by counsel, or he can provide it to counsel, filed by counsel. The state must review it, so you have to ask for it to be sealed after being reviewed by the state.
Understood, Your Honor.
All right. State, do you understand what what I'm saying is he has to file it, and then upon your ability to review it, then he can ask the court to seal it.
Yes, Your Honor, I understand. Thank you.
All right. Anything further? I think I covered everything I wanted to cover. Anything further from the state?
Nothing further from the state.
Counsel?
Nothing further from the defense, Your Honor.
Thank you.
May I be excused, Your Honor?
Yes.
Thank you, Your Honor.
Jonathan Torres Gutierrez?
Yes, Your Honor.
All right, Mr. Torres Gutierrez, this is case number 2019 CF 13009AO. The court finds probable cause for grand theft. Bond remains set at $2,500. 2019 CF 13010AO. The court finds probable cause for grand theft. Bond remains set at $2,500. 2019 CF 12963AO. Larceny. Bond remains set at $1,000. The court does find probable cause for that charge as well.
Your Honor, I have it marked at 2,500 again for the 2019 CF 12963. Are you reducing it to 1,000?
No, it's 1,000.
No, I believe it was 1,000.
Okay, thank you.
There was a bond correction on that one.
Okay, thank you.
Jordan Damian Haley. Mr. Haley, this is case number 2021 CF 13270AO, and the court does find probable cause for robbery with the threat of a weapon. Bond is, there was a bond correction on this case, and bond stays at $10,000. As to count 2 grand theft, bond stays set at $150. Thank you, sir. Mario Jose Herrera Jr. Mr. Herrera, the court does find probable cause for battery on an emergency medical care provider. Bond is set at $2,500, and battery on a uniformed or licensed security officer. Bond is set at $150, and this is case number 2021 CF 12309AL.
Your Honor, would you consider pretrial release? He does qualify, and if you look,
Yes, ma'am, I would consider pretrial release. State, any objection to pretrial release? He qualifies for pretrial release.
Can we confirm that battery is not one of those that are listed as,
And they,
dangerous crime?
oh yeah, you just showed me that. Yeah, no, wouldn't it be? It's battery, so it would be.
Well, I think it was specified as domestic violence before, so we would have to actually look to see if.
Oh, let's look back again then.
One of those.
I think I may still have that same statute pulled up, but we'll see. I think I may have looked at a couple of other statutes when I was in the office, but I may have looked at them on a different page. So let's see if I still have it. I still have it. Aggravated battery is included, simple battery is not. Is this considered to be an aggravated battery by virtue of the designation of an emergency medical care provider and a security officer, or not?
As it is a felony, Your Honor, I would argue that it is aggravated.
I'll do a bond and PTR, but it's going to be a reduced bond. So as to the battery related to the emergency medical care provider, the court will reduce the bond to $500. And as to the battery on the uniformed medical office or security officer, $150. The court is ordering bond and the PTR program, both. Defendant is ordered to not return to the location where this incident occurred. Defendant must surrender any firearms or weapons within 24 hours of release.
Okay.
Thank you. Jean Charles Pryor.
His behavior, Your Honor.
All right, reset him for tomorrow.
Oh, no, Your Honor, it's okay. I will waive the appearance.
All right, the defense is waiving appearance. The court does find, this is case number 2021 CT 69, let me start over, 2021 CT 6795 AO, DUI. The court finds probable cause, DUI with damage or personal injury. Bond stays set at 1,000. 2021 CF 13272 AO, harm to a public servant. Bond stays set at 1,000. 2021 MM 7138 AO, bond stays set at 500. 2021 MM 7139 AO, bond stays at 500. 2021 CF 13271 AO, can't read my own handwriting. Oops. I think it's 2,500. I just can't read my own handwriting. Bond stays set at $2,500.
Any action on the item bond, Your Honor?
Oh, as to the battery domestic violence prior, the court will take no action. Marina's Resi,
Let's see, it's medical.
all right, reset that for tomorrow. Mr. Resi,
Your Honor, I'm okay with waiving
Oh.
that appearance as well.
defense is waiving the appearance of Resi. So as to 2021 CF 1327, 4 AO count 1, the court finds probable cause, bond stays at 1,000. And as to count 2, bond stays set at $250. Garrett Sample,
He's hospital, Your Honor.
reset it for tomorrow.
Your Honor, again, I'm okay with.
Okay, the defense is waiving 2021 CF 13243 AO. As to count 1, the court finds probable cause, bond stays at $5,000. Wait, actually, there was no field test for this. Is there a field test required for the fentanyl?
No, Your Honor, there was.
No?
And in addition, Your Honor, he did admit that it was a mixture of fentanyl and heroin.
Well, he was under the influence though, so who knows whether he was right about that or not. I will go ahead and find probable cause. $5,000, the defense isn't jumping up and down proclaiming that I shouldn't, so I guess I will.
No, Your Honor, I originally, before, where I was talking about this case, my argument would be the same as yours, that there is no PC for the possession of fentanyl.
Well, she's right, though. He was talking out of his head the whole time, though. I mean, honestly, I don't know whether he said words that the officer relied upon. So I'm going to go with that. And I'll find the probable cause based on his words.
And Your Honor, giving, I would just ask that you take that into consideration when setting the bond.
Well, I will set the bond. Fentanyl is deadly dangerous. No, $5,000. And resisting an officer without violence stays at $150. Pedro Oscar Santana Arroyo. Mr. Santana Arroyo, you have multiple failure to appears in case number 2020 CF 13063. Bond stays set at $5,000 on count 1 and $250 on count 2. In case number 2020 CF 1424330, bond stays at $5,000 on count 1, $250 on count 2, $250 on count 3. Thank you, sir.
Any action on the item bond, Your Honor?
No, ma'am. No, the court takes no action on the possession of cannabis charge. Ashley Sue Vernon,
He refused court, Your Honor.
all right.
And I will waive the appearance.
Appearance is waived in case number 2021 CF 13268 AO, Ashley Sue Vernon. The court finds probable cause for criminal mischief. Bond does stay set at $1,000. Stephanie Louise Waterman,
Yes, ma'am.
for failure to appear in case number 2021 CF 3609A. Count 1, bond is staying at $2,000. Count 2, bond stays at $2,000. Count 3, bond stays at $1,000. Thank you, ma'am. Spanish? One of these did I use this morning?
You know? Want the list?
Good morning, or good afternoon, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Good afternoon. O'Neill Cruz Gordilos, case number 2021 CT 5583AO.
Thank you, Your Honor. If you allow me just a moment to connect and confirm to the headsets, please.
Please do.
See.
Confirm, Mr. Interpreter.
Your Honor, the interpreter can confirm the defendant is able to hear through the headset.
Thank you, Mr. Cruz Gordilos. In your case, you failed to appear. Bond will remain set at $500. Thank you, sir. Harry Colon, case number 2021 CF 13256AO. Oh. As to Mr. Colon, are we confirmed? Very good. Mr. Colon, the court finds probable cause for count one burglary of a conveyance. Bond stays at $3,500 in that count, and petty
Your
theft
Honor?
count two. Yes, sir?
My apologies, Your Honor. I was confirming with the defendant. I was unable to hear you, Judge. My
Oh, I understand. I'll repeat it. The court finds probable cause for count one, burglary of a conveyance. Bond stays at $3,500. Petty theft count two, bond stays at $100. Thank you, sir. Carmen, for,
Can you repeat?
did he not hear? Could he not hear?
Señor, ¿usted no escucha? Usted me confirmó que había escuchado.
Can you hear now, Mr. Colon?
Sí.
All right, as to the first count, burglary of a conveyance, bond stays set at $3,500. As to the second count, petty theft, bond stays at $100. The court does find probable cause on both of those counts. I have appointed the public defender to represent you. Thank you. Carmen Delia Ferrer. Ms. Ferrer, this is case number 2021 CF 7191 MO, is that right? Where does the M come from?
Your Honor, the
That many
interpreter can
defendants?
confirm the defendant is able to hear through the headsets.
All right, thank you, ma'am. The bond will be remaining set at no bond for your failure to appear in this case. I have appointed the public defender to represent you. Thank you, ma'am. Angel Francisco Padilla Andino, case number 2021 CF 13266AO. And Mr. Interpreter, let me know when we're confirmed that he can hear you. The court finds probable cause, bond remains set at zero, bond on count one and count two. And as to 2021 CF 12848AO, court finds probable cause, bond remains set at no bond. And I have appointed the public defender to represent you, sir. Sorry. I have appointed the public defender to represent you, sir. Thank you. At this time, Mr. Interpreter, I think that concludes the interpreter cases. Thank you. You can disconnect.
Thank you, Your Honor. Have a good weekend.